No more step up in basis for capital gains purposes for property that's not included in the taxable estate upon death. Boy, that's a lot. But the IRS just came out with a new ruling. I believe it's ruling number 2023, number 2. It might have a drastic effect on how capital gains is taxed, how it is applied in the future. First of all, you've heard me talk about step up basis for capital gains purposes in many other videos. And basically it goes like this. If you are a parent and you purchase a house, say in the 1970s for $10,000, when you die, that house is worth $200,000, and you give the house to your children as part of your estate, whether it's a will or by intestate succession, they inherit the property at the step up basis of $200,000 for capital gains purposes. That means if they turn around and sell that house for $200,000, there's no capital gains due. However, the mistake that a lot of parents make is that they try to give that property to their children before they die. So if that same parent bought that house for $10,000 in the 1970s and they gave it to their children today in 2023 and the house is worth $200,000, the parent has triggered a capital gains event of $190,000. And I know what you're gonna say because we get it all the time in our comments. Well, I fixed it because they only sold it to me for $1. It doesn't matter what you sell it for. That's clearly fraud. What matters in the eyes of the IRS is what the actual appraised value of the property is on the date of transfer. So if your parents give you a piece of property during their lifetime and it's valued at $200,000 and they bought it for $10,000, then there's a capital gains event of $190,000 that taxes have to be paid on. So why is the IRS ruling so important for estate planning? Well, because it has to do with the taxable estate. Now, if you have a revocable living trust, or even if you have a last will and testament, or you don't have anything at all, if that property is transferred after your death and it's part of your taxable estate, in other words, your estate, what you owned when you pass away, that's your taxable estate, then in that case, the step-up basis will still apply. So if you have a revocable living trust and you've put a piece of property in there and you say that when you die, that property goes to Enrique will inherit that property still today as of 2023 at the stepped up basis of $200,000 instead of the $10,000 that mom and dad bought the house for in the 70s. And the same goes if it was transferred during the probate process with either a will or not a will. But where this ruling affects people is on irrevocable trusts. So you always hear me talking about revocable trust, but there's also something out there called an irrevocable trust that people use for purposes of going into assisted living. When you go into assisted living, you have to draw down your assets to a certain point before government benefits start to kick in. So what a lot of people do is they put their money, their house, into what's called an irrevocable trust, where they essentially cannot really have anything to say about the property anymore. And the question has become whether or not on death, that property is part of the taxable estate when a person dies. And so what this ruling is basically saying is that if your property is in an irrevocable trust, in other words, you did not have any control over it anymore, so that they are taking the position that when you die, that was not part of your taxable estate anymore. And that means that if it's not part of your taxable estate, the capital gains should apply and you don't get the step-up basis. So if you have your house in an irrevocable trust and you pass away and say you still give it to your son Enrique, well, now Enrique is not going to get the advantage of having that step-up basis of $200,000. Instead, he's going to inherit the property at the appraised value of when you purchased the property at $10,000. That means that when Enrique decides to sell that house, he is going to have to pay capital gains on $190,000. You see how significant this ruling could affect people if they have their property or they have created an irrevocable trust and put real estate or other assets that can appreciate into the irrevocable trust. Their heirs may be slapped with a very huge capital gains tax. This is going to cost thousands and thousands of estates, thousands and thousands of dollars. So if you're in that position, might be a really good idea right now to talk to your estate planning attorney. If you have an irrevocable trust, talk to your tax professional, talk to your financial planner, and see what can be done so that your heirs are not stuck with a huge taxable capital gains bill when you pass away. Thanks again to Abby White for editing today's video. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.